your former spouse will no longer want to cooperate and give you the documents perhaps that you're looking for. So now the Home Office helpfully do assist with that side of it. If there's any concerns that you have, that for example, your spouse is refusing to give you documents, but you need to show that he was working on a particular date for you to succeed under the scheme, you don't generally need to worry about that now, because as long as you have sufficient information about your former spouse, the Home Office are obligated to look for that information and to let you know whether you succeed or not. Now that's slightly complicated these days by the Data Protection Act. Data protection means that because the documents are in the name of another person, so as I said, your former spouse, you can't ask the Home Office to disclose that evidence or information to you. You can only ask the Home Office to look at it when they have obtained it and tell you whether you succeed under the scheme based on the information that they have seen. Now already, I think certainly for me as a lawyer, that brings about all sorts of questions and all sorts of problems. Most notably, and I'm trying to find a way to say this in a relatively polite way, where the Home Office have misread the documents that they're looking at, misunderstood the documents they're looking at, and have decided that you are not entitled to reside because your former spouse was not working at the relevant time or for the relevant period. You can't tell the Home Office that they must disclose those documents because they are not your documents. They're the documents of your former spouse. So these are some of the areas where I would strongly advise people that if some of these are your difficulties, that you seek legal advice. You've only got till tomorrow. Because of course, I've mentioned the deadline tomorrow, 30th of June. After that, we're in what I call no man's land. We simply are not sure what the Home Office are going to do. They may grant another grace period, because we are already, of course, in a grace period. The 30th of June is a grace period, because from the time the UK exited or left the EU up until the 30th of June, a whole 6 months has passed. So given that those 6 months have passed, that's why I call it a grace period. So some people are saying we need another grace period on top of the first grace period. We don't know whether the Home Office are going to bother to do such a thing, or whether they effectively will find that everybody who stays here after the 30th of June, who hasn't sought to regularise their stay, then becomes an illegal immigrant in the United Kingdom. And of course, that is one area where there's going to be, I think, a lot of anxiety from people, especially if you had a right of residence previously. Now, there's also another category of people, and I suspect, frankly, that this is going to be a bigger problem than those who didn't apply by the 30th of June. And that is this. At the end of December, some people's rights were extinguished. So if you remember what I said earlier, if you're not in the United Kingdom on the 31st of December, you cannot claim successfully under the EU settlement scheme if you are a certain type of family member of an EU national. So those who don't need to worry about the sentence that I just gave or just made, those who don't need to worry are spouses and children under 21, parents, grandparents, grandchildren, great-grandchildren. Because you are protected to some extent. That doesn't mean you don't apply. You still have to apply, but the route for you is a much clearer one. The route that isn't clear is for anybody who falls outside of those categories, such as cousin, brother, uncle, sister, nephew, niece, etc. Because under the old EU law, so under the latest regulations, I suppose, if you look at the 2016 regulations, what they allowed for was what we called extended family member. So that's everybody who wasn't related to you in a line going up, a vertical line going up, or a vertical line going down. So what I mean by that is if you're in the middle, your parents are the generation above you, your grandparents are the generation above that. And again, if you're in the middle, your children are the generation below, your grandchildren, the generation after that. So anyone in those categories that's for either above you or below you in terms of being your relative were permitted as family members to come to the UK, remain in the UK without too much difficulty. And then in the 2016 regulations, we had what were called extended family members. So effectively, everybody else. So we're talking about, as I said, cousins, nephews, brothers and sisters, etc. Those people were allowed to come to the UK or remain in the UK as your extended family member only if certain conditions are met. The rights of those people were expressly extinguished after the 31st of December. So if you were then applying for such people after 31st December 2020, you'd have a bit of an uphill struggle where that person did not come into the United Kingdom with a family permit or had a right of residence as your extended family member under the EU scheme or under the EU regulations. Now, what I've just said is a bit of a mouthful, I know, but it's quite important. So I'm going to repeat it, but perhaps try it in a slightly, I suppose, bite-sized way. If before the 31st of December you were an uncle, aunt, etc. of an EU family member, EU national, that made you, and continues to make you till today, an extended family member. Extended family members' rights were extinguished on the 31st of December 2020. So if, for example, you were in the United Kingdom after the 31st of December, so you cannot say you were here before 31st December, you would not be permitted to achieve or obtain leave to remain in the United Kingdom under EU settlement scheme. Even for those who were here before the 31st of December, there have been, from my experience and those of my colleagues, a number of refusals because you didn't apply before the 31st of December. But then if you can give a good reason as to why you didn't apply, if you can give a reasonable excuse, there may be some leeway from the Home Office as to whether you succeed or not. But again, I'm afraid, viewers, this is one of those areas where there's a big question mark. We don't know. Home Office hasn't said expressly. They've given us a lot of information, but we're not quite sure whether it's going to work that way or not. Now, what I'm going to do is I'm going to read you something actually that is relevant directly from what the Home Office have said. And I'm actually going to read it out because I think it's quite helpful. And I'm going to read the parts that are relevant. So if I pause a bit, it's because I'm skipping over the bits that are not. And it says an EEA, so take it from me, EU, right? Citizen or their family member who is resident in the UK at the end of the relevant period, but who does not have permanent residence and is not working, will still be able to apply to the EU settlement scheme by the deadline of the 30th of June. So I keep mentioning this because it's important because it's tomorrow. They will not have residence rights under the EU scheme protected during the grace period, which is their current position, and they will not be able to start exercising free movement rights in the UK after free movement has ended. However, they will still be able and are encouraged to secure their status under the UK law to continue living in the UK beyond the 30th of June 2021. Yeah? So effectively, that's again another sledgehammer reminder that please, 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 by tomorrow, if you haven't already, stay up tonight, tomorrow morning, afternoon, evening, and get your applications in. They're online applications, so you just type in EUSS in a search engine, and you will then be able to look up the EU settlement scheme. It has different boxes, different categories, and then you tick those that apply to you so that you can apply under the scheme and then have at least some security that you've made the application, you're not in the UK unlawfully, or illegally, and therefore are able to take advantage of the rights once they're given. Again, one of the concerns that we have is what happens after the 30th of June in terms of applications. So remember I said that there's going to be another grace period, or what are the government going to do? What certainly seems clear to many of us is that after 30th of June, there will be probably a requirement, if you are going to make an application, to pay for the application. Now, I can't even say it's going to be the same type of application. I don't think it will. But if you find that after 30th of June, and the legislation is then published, or it becomes law and then published, and then you find that you can make an application, most certainly there'll be paid applications. Because of course right now under the EU SS, the applications are completely free of charge. Under the immigration rules, so under the laws of England and Wales, under UK legislation right now, if you were a spouse coming from an overseas country to live with your spouse who lives in the United Kingdom, and you needed a visa to come here as a spouse, you will be paying over £3,000 for your application, because it'll be the application, it'll be the immigration health surcharge, some other checks and things that you need to do. So roughly around £3,000 are the sort of sum that you're looking at. Right now, the same spouse under the EU settlement scheme pays nothing. Yeah, so it is very important to know what your rights are and what you can sort of take advantage of. Because if, of course, you're here as an EU national, you have a spouse, you have 3 children, for example, that's £12,000 if you have to then make an application for each of those persons after the 30th of June. And if it's under UK law as it is now, the minimum period of that £3,000 will be £3,000 now, another £3,000 in 2.5 years' time, and another £2,500 in 5 years' time. So there's a lot of money involved, and I won't go into all of that, but all I need you to know is that there's a lot of money for the average person to be paying only to get 2.5 years permission to stay in the United Kingdom. So again, those who think they have an entitlement under the EU settlement scheme, make the application. The worst that can happen is the Home Office simply say, refused. The only people possibly, however, caveat to that, the only people possibly who may have some difficulty is if they refuse you, they didn't even know you were still here in the UK, and now they do know you're here. So of course, is it a risk worth taking? If you think you have some sort of right, because you have a family member who's an EU national, then please do investigate, speak to a lawyer urgently by tomorrow. So you make the application, so you secure your position, so we ensure that you can continue to live in the United Kingdom and then actually work, because most people who come to the UK under some sort of scheme or employment, etc., just come to work, want to make the money, send the money home or settle in this country, etc., but want to work in order to live. So secure your position. What I had mentioned earlier on was about family members, I think I did anyway, family members who are outside the UK. So if you are, an example, a French national, and you're a French gentleman, and your Nigerian wife lives in Nigeria, and you want to bring her to the United Kingdom, but you as the French national gentleman are living in the UK. What you do is you make an application for your wife under the EU family permit scheme. It's the same thread, bringing people under UK law rather than under EU law, because we have left the EU. But again, such applications must be made by tomorrow. The difficulty, of course, with those applications is the person's not here, so you can't sort of look for alternatives sort of in the meantime, or look at ways of shifting or changing category so easily. But nonetheless, if you have an entitlement because you are the spouse of an EU national, please, 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 if you take nothing else from this evening, apply by tomorrow. if you don't, then you will fall under, most likely, the UK rules that I told you about, the £3,000 payments and all that sort of stuff. And when it comes to UK legislation, it is a lot more stricter than EU regulations and legislation. So many other things you have to show, so much you have to prove, so much you have to show almost in advance of you even arriving in the United Kingdom. Anyone who's come to see me and be my client, if they look at the EU list for spouse compared to the UK list for spouse in terms of what documents you need, we'll see a vast difference between the documents that are needed in either case. And sometimes the UK cases can be rather overburdensome because there's so many documents, at least showing a history minimum of employment of 6 months and all sorts of things. Whereas under the EU regulations, you don't need to show that your French spouse living in the UK has been working for 6 months. You don't need to pay for the application, you don't need to pay immigration health surcharge, none of these things. So, as I said, applications by tomorrow, and then at least you've got your foot in the door. If any of you have looked at the government website or looked at the guidance, they are also saying that after the 30th of June, even if you've applied by the 30th of June, you can't travel on a family permit after the 30th of June. So if you apply tomorrow, and of course you're not going to get the decision in the same day, you then go and do your fingerprints and photographs maybe in 2 weeks' time. Then after that you sit and wait, and you're granted. You cannot travel on a family permit because they no longer exist after tomorrow. So again, that creates more confusion, in my opinion. So if I'm applying for a family permit, this being the question, apply for a family permit, I am granted under the legislation that gives the family permit, but I can't travel because you no longer issue family permits. What happens to me then? I'm afraid, again, this is going to be one of those areas of we are waiting to see. Government, again, haven't issued comprehensive information as to what happens to those people. However, what I can be certain of, having practiced in this area for many years, is the government cannot simply fold its arms and say, well, you applied the day before on the day, your problem, we're not going to do anything about it, stay where you are, enjoy the country that you're living in. They can't do that. Because, for example, you have people who applied at the beginning of the year. I've got clients who've been waiting months now. You've got people applied in February, March, whatever. And those people can't unfairly be penalised because the government didn't make the decision in good time. So people shouldn't be too anxious. Again, I repeat for the umpteenth time this evening, make the application. We can worry about what happens if you're granted once we know more about what the government have said in terms of what the deadlines are going to be after the 30th of June and who can and cannot succeed. I need to also perhaps tell you about the exceptions, because I think earlier on I touched upon what happens if you haven't applied by the 30th of June. Are there any exceptions? Is there anything that you can do? It has to be the case that because of COVID-19, coronavirus, that there are going to be people who are going to not succeed under the scheme because they haven't been able to apply before the deadline. Sadly, because of the way the coronavirus works, you can be well one week, ill the next. People have got long COVID, people have been bereaved, lost family members to coronavirus. And so, much apart from that even, there are going to be people who just simply don't apply by the deadline. There are some clear exceptions to the 30th of June deadline, and there are some that are not so clear. So I've told you about the ones that are not so clear. You just simply haven't applied. What's going to happen to you then? But some that are clear, which again I'm going to read, the exceptions to the 30th of June deadline can include those who have pre-settled status. There are two types of grant that you get if you apply under the EUSS. They'll either give you pre-settled status or settled status. In other words, 5 years leave to remain, or indefinite leave to remain. Yeah? Pre-settled, settled, 5 years leave to remain, indefinite leave to remain. Okay? So if you've been granted pre-settled status, once you've been resident in the UK for 5 years, you can apply for settled status. All right? Settled meaning indefinite leave to remain. So those are an exception under the 30th of June deadline rules. Just because you were granted pre-settled status on 2nd of January 2021, that doesn't mean that when the scheme comes to an end on the 30th of June, you then fall by the wayside. No, your pre-settled status continues after the 30th of June until you have accrued 5 years, and then you can then apply for settled status, indefinite leave to remain. Okay, so hopefully that's quite clear. Excuse me. The other people who are the exceptions, as I said, family members coming to join their sponsor in the UK holding a family permit, but they still have 3 months to arrive after the 1st of April 2021. So it still brings you up to 30th of June, in fact. So such people, even though they're called exceptions, you still have the same deadline of the 30th of June 2021. But I think the point being, if you have been granted a family permit after the 1st of April, you can still then continue to rely on that family permit after the 30th of June, because family permits are for 6 months. So effectively, you're talking April, May, June, July, August, September in theory. So even though your family permit could comprehensively finish on the 30th of June, it doesn't, because it was issued before that date and therefore continues until it ends. Okay, so that's another exception to the 30th of June deadline. So they don't just suddenly cut you off if you are here by the 30th of June 2021. There are a few other exceptions, but I won't necessarily go through those because I don't think those ones also are very common. So again, it depends on your circumstances. I would again advise you to seek legal advice in order to be able to understand and perhaps take advantage of the scheme that works for you and your family members. Okay, so we've looked at family members, we've looked at extended family members. We've looked at family permits for family members. I think I've mentioned it already, but I'm going to say one thing again. The family permit scheme, which is the scheme that allows you to come into the United Kingdom as the family member of an EU national, does not extend to extended family members. So if you're in the middle again, those above and below are entitled after the 31st of December to apply for a family permit. Those who are not either related to above or below, so they go along, so as I said, brothers and sisters, cousins, etc., uncles and aunts, those people cannot apply to come to the United Kingdom after 31st December 2020. Now, I say they can't apply. Anybody can make any type of application they want, but you are not going to be successful in your application. Again, because of the exceptions and things like that, we don't know if reasons are given. So I was unwell, I had coronavirus, etc., whether those will create an exception. But I would strongly advise people to again seek legal advice because it depends on your circumstances. Okay, so one other part that I think would be helpful to those watching and to family members to look at is a change that came about on the 17th of June, so middle of this month. Some of you will have heard of a case called Zambrano. Zambrano was a case that was decided a few years ago that talked about parents of British citizen children. There is a strand of EU law that allows British citizens to have certain rights depending on what category they fall into. And I'm not going to go into all of them because there are a lot. But what I will talk about is the recent judgment on the 17th of June. The original Zambrano judgment came about because British citizen children are allowed to exercise treaty rights outside of the UK. So you as a British citizen child could decide to live in France, Germany, Italy, Spain, those EU countries that I mentioned earlier. But then what happens to your primary carer, your parent, the person looking after you? And what Zambrano said is that the child can live anywhere they want to. They have a right to exercise treaty rights, to move about, to roam throughout Europe because they hold a British passport. But the parent of that child does not have an automatic or direct right if they are a non-EU national. So what we call third country nationals. So usually Asian countries, African countries, America, etc. So those people, if you had a British citizen child and that child was in the United Kingdom, you as the parent can make a claim that I am the primary carer of that child and therefore I should reside with the child in order to help the child, support them, etc. Because the child, first of all, can't live by themselves, too young or underage, and they certainly can't live in another European country by themselves. Now this applies to all parents of British citizen children. The difficulty we had after Zambrano and before the 17th of June was that because the UK exited the EU, those people then fell between the cracks in some ways, because the government said that, well, okay, you may be a Zambrano case, but the original Zambrano case in the legislation says that a parent usually is given around 3 years the right of residence in the United Kingdom. But that right can never be turned into a permanent right of residence. So when Zambrano came out, people were able to take advantage of it, but never were able to claim that, okay, I've done 3 years, I've done 10 years, I've done 20 years, etc., etc. I now am entitled to permanent residence. It was not possible under the legislation as it was. So a lot of those parents then switched to what we call the 10-year route, which many of you who are watching this program will know, which is where, because you have a British citizen child or a child who has a right of residence in the United Kingdom, you then are granted 2.5 years to stay in the United Kingdom and another 2.5 and another 2.5 till you get to 10 years. And what the case on the 17th of June said is that no, you can't cut people off in that way. If a parent is a Zambrano parent and they then have been put on the 2.5-year route, so 10-year route for 2.5 years, and they then come back to Zambrano, you can't tell them that they're not entitled to indefinite or permanent residence, because all the EU legislation effectively has to be looked at the same under the current UK law. The current UK law didn't make any distinction between the two. So if you're a Zambrano parent, you can actually get indefinite leave to remain, finally, because this wasn't allowed previously, but now you can. So if you are the primary carer of a British citizen child and you live in the UK and the child cannot live by themselves in another EU territory without you, and there are no alternative arrangements for the child, then you are entitled to stay in the United Kingdom with that child. And your right accrues from when the child's right accrued. Okay, so if the child's right accrued at a particular date, doesn't mean that yours starts from 0 today. So there are a lot of people who don't have to keep paying the large Home Office fees and are entitled to indefinite leave, whereas right now they may be on the 10-year route to the 2.5 years that I mentioned earlier. Or they may even be on the Zambrano route of never being able to get indefinite leave to remain. You now can get leave to remain, yeah, indefinite. So looking at that and what that means, it means that parents who are primary carers should be applying under the EU settlement scheme. But I've had a couple of interesting queries from people. And one of those queries is, well, I live with my spouse. I've got 2.5 years. He's got 2.5 years. Can we apply together under Zambrano? or under the new Zambrano, I should say. I would say jury's out, but I do have an opinion on it. And my view is that it would be very difficult, because the cases that I have done, the cases I know my colleagues have done that we've been successful on, are where the primary carer, so the main carer for the child, is usually a single parent. The other parent has disappeared, not in the picture, not engaging, not taking much care of the child, or has expressly said, I'm not interested in looking after the child. Yeah? So, certainly not full-time anyway. So those are, if I call them the new Zambrano cases, where such a parent would be entitled to indefinite leave to remain. But if both parents are on the scene, both parents take an engaged interest in the child's upbringing. For example, both parents are married together, or is a step-parent. There are so many variations. Could you succeed under the Zambrano? Perhaps as a step-parent there'd be a different issue. But if you are the mother and you want to use the new Zambrano idea, and the father lives with you and the children, then you cannot say that there is one primary carer. The law doesn't say there can only be one primary carer, but I think I would argue common sense approach. Primary usually means the first. And usually one parent plays more of a significant role in the child's life than the other. Again, not to say that you can't try, but you have to be cautious and prepared for the fact that such an application may not succeed. So you need to be aware of that. Again, you do, in my opinion, need to take proper legal advice in order to understand what your rights are. So what I'm going to do is I'm going to go through the pertinent points that I've already mentioned and the points that I think people need to understand, okay? Because I think that the deadline is so tight that I really would find it a great shame, frankly, if certainly there are people out there who haven't applied under the scheme. You can apply up until tomorrow. You can apply online, so as soon as you click the button, your application has gone in. Even if after that you have to then go and do your fingerprints and photographs, which most people have to these days. So you go to an external centre outside of the Home Office where they take your biometric information, they call it, but it's your fingerprints and your photographs. Even if that date is 20th of July, 30th of July, 10th of December, as long as your application is in by tomorrow, it doesn't matter when you do your biometrics, yeah? Just please, please, please click those buttons. Even if you don't have all of the documents that need to go with your application, because it is an online application, there is a certain exception to it, which is that you can continue to upload, so continue to put or send to the Home Office, the documents that you think are relevant to the application, even after tomorrow. So if you know that you are applying, for example, under what I call the new Zambrano, so because of your child, and you want to apply tomorrow, but you haven't got a copy of your child's birth certificate to upload, you haven't got a copy of your own passport to upload, as long as you have the details, so you know your child's name, date of birth, where they were born, you know your name, you have your passport number, validity dates, etc. of your passport, you can still make the application. You can still do it online. You can still submit it online. So press that click button, send, and your application is considered as having been submitted to the Home Office. Even if you have applied for another copy of your child's birth certificate because you've lost the original, you will still be considered under the scheme as long as you apply by tomorrow. So don't be afraid or worried that I've got documents missing. I don't know if I can prove all of this to the Home Office. As long as you have the relevant information, you can still submit the application. And you will be surprised to know that the application process, the form itself, is relatively straightforward. Basic details are taken at that stage. you can always send in more information to the Home Office later before you go and do your fingerprints and photographs. In fact, currently, and I emphasize currently, in capital letters underlined, even after you've done your fingerprints and photographs, you can still submit more evidence. That is an exception to the rule, because under every other type of application, under the immigration rules, you cannot submit any further documents after you've submitted for biometrics, after you've done fingerprints and photographs, unless you pay. So more fees to be paid to the Home Office. So again, if you're applying under the EU settlement scheme tomorrow, just do the application. And then we can look for the documents after that, submit them after that. And even better than the information I've given so far, maybe as a combination of COVID, a combination of losing documents, etc. The Home Office now look at documents that are submitted online. They do not require to see your original documents, unless there's an exceptional reason for that. But certainly for the last 2.5 years or so, or 2 years that I've been doing applications that have been submitted online, we haven't needed to submit an original document of anything to the Home Office. Everything has been scanned, and now you can scan on your phones, not just photograph, but actual scan on some phones. Scan and upload to the Home Office, or have a scanning machine, upload to the Home Office. Even photographs you can upload. But again, just check when you're doing them, because there's some types of photographs they will accept and some they won't. So the EU settlement scheme, even though it's coming to an end tomorrow, if you think you have an entitlement under it, you can still make the application. Do the application by tomorrow. I can't say it enough times. Please do your application by tomorrow. Look for the documents after, if that's the concern that you have. Book an appointment for your biometrics, maybe in 3-4 weeks' time, to give yourself a chance to find the documents you can't find right now, and then submit those documents as a cautionary before you go for your biometric appointment. Because this, as I said, the ability to submit documents after your biometric appointment, I don't know whether that's going to exist after tomorrow. So as a precaution, before you go for fingerprints and photographs, upload your documents. If you can't upload documents, if there's some difficulty, you can always write to the Home Office and explain, or even put it within your application. I can't find this document. As soon as I get it, I will send it. Unlike under usual immigration rules applications, under the EU settlement scheme, there's a phone number where people actually do answer the phone. They do pick up and they do speak to you. I've recently heard, unfortunately, that seems to be going away by the wayside, because it seems that they are overloaded or overrun with applications. So that seems to be becoming more difficult. But there is a phone number. There is so much information in the EU settlement scheme, perhaps more, in my opinion, than there is under anything else that's being done at the moment. So again, please do take advantage of it, read through the literature. So as I said, whilst I've finished off in terms of how to apply, when to apply, what to do to apply, documents you need to apply, perhaps the one document that you do need, of course, is a passport. If you don't have a passport, you can actually apply under the EU settlement scheme without a passport, but those are only paper applications. So again, go online and check the scheme, because if that's a paper application and tomorrow is your deadline, it may be that if you post it tomorrow by recorded delivery, special delivery, those are accepted, but if you send it by first class post, it isn't. So check online, get legal advice, speak to a lawyer, get comprehensive and clear advice, so that if you don't have a passport but you still want to apply under the scheme, you may be able to, because paper applications are documents that the Home Office are prepared to look at as well. Yeah. So again, do not be afraid to talk to a lawyer and get the right information, because again, what would be a pity is if you don't apply. The number of people I've had come to me who are extended family members, you remember who I said they were? Extended family members who didn't apply before the 31st of December and now are saying to me, what can we do? What are the alternatives? how can we stay in the United Kingdom? And unless we are able to navigate what I consider to be a minefield in terms of the EU settlement scheme, we're going to have a lot of people in that category who may find themselves in the United Kingdom illegally. Don't be one of those people. Apply by tomorrow. Family member, EU national. Do not think because you're an EU national you don't need to apply. You do. It applies to everyone who is claiming a right of residence in the United Kingdom under the EU scheme, under EU legislation, under EU law, because of the country that you're from, passport that you hold, or because you're a family member or extended family member of an EU national. All of you need to apply, because otherwise, after 30th of June, after tomorrow, the general provision we suspect will be you're in France. I seem to be using France this evening, so let's continue. If you're a French national, you want to come to the UK after the 30th of June, what we think will happen is that you will have to apply for a visitor visa, much the same as UK nationals that want to go abroad. What scheme are you going to be under? What legislation are they going to put in place that means that you can't just simply hop on a plane, as we used to do, and go to Spain, go on your weekend holiday in the south of France, go to Portugal into the sun. So we need to make sure that those who are in the UK, who are EU nationals or their family members, are able to continue to reside in the UK and can continue to have what we call free movement. We in the UK are losing the right to free movement on the continent. We need to look at things like our own health insurance, because remember we used to get those European health insurance cards. The validity of those have gone. What insurance you need to go abroad? What visas do you need to apply to travel abroad? Do you now need to get injections? You know, in some countries you need to have certain injections in order to travel. Are we going to be subject to those laws? Those who want to come in from the EU to the UK, will they be subject to such laws? Because right now, if you're coming to the UK from certain countries, you need tuberculosis, you need English language tests. Those coming from the EU, are they going to be subjected to an English language? Again, another big advantage, which I haven't mentioned, under the EU settlement scheme, is you didn't have to show that you could speak English. Now, the English test, I always tell everybody, is really easy, but that's me saying it's really easy. But it's your name, how are you, how did you get here today, where are you travelling to, what do you know about the UK? So basic questions that are conversational English. But the problem with those is that if you don't know how to speak English, you're not confident in English language, you've tried so many times to pass and you can't, and I do know some people who've done that, then people in that category appear never to be able to have the right to come to the UK. Now, again, to every rule there's an exception, but those exceptions are not easy. So get your application in tomorrow. In fact, get your application in today. As soon as you've listened to me, and you've finished listening to my advice, get your application in today. Don't go to sleep, don't go to work, get it in, because otherwise, by the end of tomorrow, you may have to think about alternative arrangements, unless, of course, your plan is you don't want to stay in the United Kingdom. In which case, great. You can leave the UK and go to whichever territory it is that you've planned to do so. But when coming back to the UK or when visiting this country, you will need some sort of visa. You can't arrive at the border and simply be let in. You will have to have some sort of visa that grants you the right to come to the United Kingdom. Now, if we look at countries like the USA, they are granted the visas upon entry, at the time of entry. Is that going to be the system that's in place for EU nationals? We hope that at least there's that. So if you are a passport holder from France, that you will be able to come into the UK after the 30th of June with your French passport, board the plane, get here, and once you're here, speak to an immigration officer who'll stamp your passport, allow you entry for 3 months, 6 months, whatever it is, into the UK. If you're happy with that, then that's fine. But what you can't do, the big one, the obvious one, is you cannot work. If you wanted to get a different type of visa that allows you to work, such as a business visitor, because you have some sort of business dealings that you're doing in the UK, or a tier 2 or a tier 4 or tier 5, whatever visa, those you have to apply for before coming to the UK. Yeah, so I am hoping that this evening everybody is listening attentively to what I'm telling them, listening attentively to whether they fall in that category, their friend does, a family member does. Do we need to apply? Should we do the application tonight, tomorrow? Please do, because if they're not done, you're going to give yourself the biggest challenge in trying to convince the Home Office why it wasn't done. There is a famous sort of, I suppose, saying, adage in English law, which is ignorance of the law is no excuse. So ignorance of the law when it comes to criminal law. So I didn't know that slapping somebody was an offence, is not a defence to why you slap someone. However, what we're hoping is that if you say, well, I didn't know the applications had to be in by the 30th of June, you would at least have to give good reason as to why you didn't know. You can't just simply say, I didn't know. Because it may be that given the number of adverts that are on TV, given the amount of pop-ups I certainly get on my computer, it'd be surprising if you didn't know. If your position is, well, I don't read English or write English because I don't have to, and I work in the UK, but everything's done in a foreign language, maybe that would be a reason that some people could justify. It may be a reason that some people could see as a reasonable excuse. But again, all of this is about proving it. Why make life difficult for yourself about this scheme? Try and make it as simple and straightforward and pain-free as possible. It is obvious to me that one thing of working in this jurisdiction is how relieved clients are when their immigration cases are resolved. So much of your life is put on hold. So much of your future progression is stagnated because of the uncertainty of your immigration status. If that is a category you could possibly fall into from the 1st of July, make your application. It goes without saying almost that if you know you've got no connection with the EU, you've got no relative who's EU national, etc., then this doesn't apply to you. I am, of course, talking about people to whom the EU settlement scheme can, does, should apply to. If you think you fall under the scheme, please, 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 please make the application. I've told you who I am. You can contact chambers, contact the Law Society, the Bar Council, contact local authority. The Mayor's office in London is very good, has a lot of information on their website to try and translate almost what the government said about the scheme. A lot of local authorities as well have information about the scheme. But I suspect if you're leaving it to this point, you're not going to get much help from the local council or from the Home Office if you phone them, because they are going to be inundated. So you are left with either being able to resolve it and look at it yourself, or seek legal advice from a lawyer. All right. Even if it is a call that I think I know what I'm talking about, I think I've made the application, what do you think? Should I be making it? Am I making it under the right category? What if you fall under 2 or 3 different categories? So derivative rights, so the Zambrano, remember I said? Zambrano new, as well as married to an EU national. You may fall under more than one scheme, in which case you may want advice as to whether you can make an application that hits 2 schemes, or you make an application that doubles up almost, so the Home Office will look at both as an alternative, or whether that's even permitted. Get the right advice, get the right information. As I said, after the 30th of June, we are in this uncertain territory. I will do another programme as soon as it is clear, and the advice that I can give will be comprehensive and clear advice to all of you, and information to all of you with regards to what happens after the 30th of June. We're all on somewhat tenterhooks about it, because this is a big change in UK law. Certainly as long as I've been practicing in this jurisdiction, it has always been the case that EU nationals and their family members and extended family members have the right of residence in the United Kingdom, as long as they can prove it. So this is a big upheaval and a big change for all of us. The government will no doubt, through the Home Office, be looking at ways of raising, I think, revenue by bringing in paid applications. If that is the case, and if that's the only concern is that you now have to pay rather than don't pay, then perhaps this is not the scheme for you. But if your only right to remain in the UK is under the EU settlement scheme, or possibly could be, then you are the person that I'm talking to, and you're the person that needs to apply by tomorrow evening, tomorrow night. Yeah? So don't let me have anyone calling me on the 1st of July, please, telling me I missed the deadline. I didn't realise it was today. I thought you meant 1st of or 30th of June 2022. Yeah? 2021, tomorrow. All right? So it means that most of this advice that I've given, whilst it applies today, will not apply after tomorrow. So again, if you are applying late, you need to go back to the drawing board and start again and look at what scheme applies to you, what rules, what regulations you can take advantage of. Are there any exceptions? Is there another transitional period, another grace period given by the government within which you fall? Keep an eye on the websites. Speak to those that you know. Speak to those who have more understanding of the legislation or law than you do. And do not be afraid to make your application as soon as possible. All right? I hope you have found this information clear. I hope you have found it comprehensive. And I hope what it's made you do is turn your laptops on now, or your phones, and think, right, as soon as she stops talking, I need to make my application. Because if you don't, as I said, don't call me on the 1st of July. As I said, be ready. Do it now. Okay? Thank you very much for those of you who've stayed and watched throughout. Spread the information, spread the word, spread the news. Tomorrow is the deadline. I can say it again and again and again because I know I'm going to get a call from someone on the 1st of July, but I'm hoping you'll prove me wrong. Okay, tomorrow is the deadline. Make your application. Be secure, be safe, be sure. My name is Linda Appiah. I have been your host, presenting as much information as I can as a barrister of England and Wales to you this evening, giving you comprehensive information this evening on the EU settlement scheme for all migrants and those of you who are not migrants as well, but who can pass the message on to those who are. Do not be left out in the cold. This evening, this programme has been brought to you by Omega Live TV. We're happy to bring this information to you this evening. We hope that you and your families remain safe and secure. And unless there's anything else, which I don't think there is, then it's good night from me, and hopefully see you in another 2 weeks. Good night, and thank you so much for watching.
Christian is a hard-working, focused young man who will go all lengths to achieve results. We have worked with him for some time now, and we will recommend him to anyone who wants to buy a land. If you want your valuations done on your land, he's the best man. If you need land title documents done for your company, I would recommend him to be the right person. In the near future, if I want to buy a land again, I will go for Christian, and I recommend you to do same.